Captain Simon and Silver Saguaro represents the chosen person. Indeed, the case is coming up for further hearing, and we are ready with prosecution witness number 2. If it may please you, Mr. Chairman and honorable members, just like to go on record about representation of the accused persons by first of all introducing myself, Lukwago Erias, as one of the lawyers. Mr. Chairman, we intend to address you on issues regarding the leading counsel, who is Honorable Martha Karua Wangari. She is a practicing advocate within the Republic of Kenya. And Mr. Chairman, she has got her certificate of practice, and she's in the process of securing temporary practice to be able to handle this case as the leading counsel. She takes charge of the entire legal team here and internationally. Other members, Mr. Chairman, for the record, Mr. Chairman, if I may pass on her documents to the judge advocate here. Mr. Chairman, we have my land friend. No, for the record, the Honorable Martha Karua is a senior advocate. She's a senior counsel. shares that title. We have my land friend Ernest Kalibala, who has been before this court since morning. We have Council Eron Kiiza, Nalukola Erias Luyimbazi, Ronald Samuel Wanda, Chintu Michael, Kato Tumusime, is Kakuru Tumusime around? Sekanja Kabubakar, Jojo William Mukula, Sekade Julius, Kunihira Proskovia, Bayan Tulinawe, Mugaga Mukuve Karemire, Katushabe Ronald, Isaac Kwagala, Faruku Kamreke, is Kabuye Lawrence around? Kato Wilson, John Mata Nsimbi, Cyrus Ogul, Tugume Moses, Akakimpa Godfrey, Muizi Samuel Mulindwa, Since she arrived in the country yesterday, she has not had any opportunity as the lead counsel to interact with their chosen persons, save for the instructions that were given formally. But as for any conversation about the matter, effective instructions and discussions, we are yet to finalize that. Secondly, this morning, Mr. Chairman and honorable members, we visited the office of the law council, and we had the opportunity of talking to the chairperson of the council, Justice Irene Muriagonja, regarding the process of securing a temporary practicing certificate as required under Section 18 of the Advocates Act. Unfortunately, she informed us that council is yet to sit and pronounce themselves on the matter. And as we talk right now, they are yet to finalize the process. The assurance she gave us is that they are going to expedite the process and that we may hear from her probably tomorrow or the day after. So that is the assurance we are given. But the long and the short of it is that, Mr. Chairman, the right to a fair hearing entails effective representation under Article 28 and the relevant authorities we have here. So we have to have the team fully constituted and also instructions effectively given to the lead counsel on how to manage the team. In other words, she's our team captain, who should be seized with all the tools and facilities to be able to take charge of the matter. And this is where we stand today, and this is critical in the dispensation of justice, Mr. Chairman and honorable members. Wanted to bring that to the attention of this honorable court. With your permission, Mr. Chairman, I would like my colleague to pick it up from there, Ernest Karibala, if you may. Most obliged, Mr. Chairman.
May it please, Court Chairman and other court members, before we proceed to have a ruling of this court.
Excuse me, we are still proceeding. Please, let us first finish our submission. Thank you very much. We are still proceeding as defense counsel. We shall not allow you to proceed. Listen to us. We are proceeding as a defense team. We are not finished.
Okay, let them finish their part.
So, counsel has no locus. This is what I'm going to talk about.
I have all the lockers. What are you talking about?
We are not for the fight.
So, Mr. Chairman,
It's their turn. You leave them, let the defense lawyers put up their...
Mr. Chairman, the prayer we are making, if we could be given time to interact with their chosen persons, considering the prevailing circumstances where we have the lead counsel who has that issue, who is incapacitated as of now. So it's not a matter for debate, Mr. Chairman, or for argument and counter-arguments.
I mean, Chairman and members of this honorable court, if I may put this point succinctly, is that the defense team requests this honorable court to talk to the clients, Besigye and Rotary, and then we get effective instructions on how to proceed, because this is not going to be business as usual. Thank you very much.
I wish, Council, you could reduce on your tune. That one has no problem. Council Lord Mayor, what time do you want to talk to him now, or you want to talk to him any other day?
No, we want to talk to him right now, but In the camera, not in public here.
Yes, we can also allow that if it is not going maybe to take a long time.
Like 30 minutes?
Yes.
I think, sir, there are legal issues before you allow them. One, the lead counsel, you are saying she has no instructions as of now. So if she has no instructions, are you saying the case cannot proceed with all these other lawyers you have introduced? And if you are not ready until she acquires a certificate, then it would mean nothing can proceed. Either you seek an adjournment another date, but giving them the minutes still will not make a difference. Because he's saying he cannot proceed without the lead counsel, who is improperly before court.
Honorable Chair, I was very clear. The instructions given are to the effect that Honorable Martha Karua takes charge as the lead counsel. And there are some legal hurdles we have encountered along the way. It is his decision to take any other decision if he so wishes. So this is the matter. This is the issue we are raising. That if there is any adjustment to the instructions, we need to confer with him or with them. So the question is, all along we have been seated outside, we have not had any opportunity of interacting with him. So right now, that's basically what we are seeking for. Like 30 minutes, we agree. We decide on the way forward, we chart the way forward after having a conversation with him over these issues. I am sure he's just getting information about what we have been doing at the law council just right now here. We had not yet even briefed him as to the progress of the matter before the law council. And these are the issues we should be discussing with him.
And for the avoidance of doubt, that's why Honorable Martha is not yet speaking. We want to talk to the two clients so that they allow us, in the meantime for today, to proceed without Honorable Martha leading the team formally, because they may ask themselves that we chose Honorable Martha to lead and we see Lukwago and Karibara. No, so we are trying to consult them to make them appreciate. So for now, Lukwago and Ernest are leading, as you have seen, and they are requesting, the team is requesting to confer with the client for 30 minutes in the camera so that we can effectively represent them. Yes, thank you very much.
You can hear from the state because he wanted to talk. They said he was within their time. Can you at least go to before the chair takes it seat?
Okay, Council Lukwago has introduced a battalion of lawyers, but among them, I think it is only 4 who have complied with Regulation 62 of Uganda People's Defense Forces procedures. That is paragraph 3. And those ones who have complied are Lukwago, Kiiza, Narukora, and Masiko. So I think the rest should not be on record. Yes, they have not complied. Read the regulation. Unless they comply with this regulation, they should not be on record. Person is entitled to appear as advocates.
Order, please.
So I will simply go to paragraph 3. If an accused is to be defended at his court-martial by an advocate not nominated by the convening authority, the accused shall give the convening authority notice of his fact not less than 24 hours before his trial. So it is only those 4 who have complied with that. even the document, this document here, which is before court, it is as if it is coming from this court. It is a Republic of Uganda, Uganda People's Defense Forces, in the General Court Martial, ordered at Machine. So this document does not bear the address of the...
So, signed by...
I don't know if you
I think, Councillor Lukwago, this goes back to what our judge advocate advised. Maybe to sort out these issues, you could pray for an adjournment and you clearly put everything right.
Prosecution is misleading this court. The instrument is reading was about law firms. It's not about the particulars of the individual advocates. Actually, where I was reading, my name is not there. It's Lukwago and Company Advocates. If he cared enough to look at the list I was reading, he would see the individual advocates and the law firm they come from. They are indicated there. So this is the list. So there's a difference between law firms and individual practicing advocates. For example, Martha Karua on this list is care of Lukwago and Company Advocates. And it is in black and white. So I don't know, his point is neither here nor there. To me, Mr. Chairman, it be considered as a very serious matter. And in any case, the lawyers are here. If you want their particulars, we can furnish them to court. They are here. So those are the things the Constitution intended to cure. Article 126. Maybe it's not applicable in this court. But if the Constitution is the fundamental law of the land here, it's very clear. Substantive justice as opposed to those minor technicalities, which are neither here nor there. So I don't think we should indulge in those gymnastics, Mr. Chairman.
These are not minor technicalities. Mr. Lukwago, you endeavored to attach your practice certificate. Kiiza, you did. This is reimbursed deed. And this is in compliance with the law. Why did you do this? So those ones who have not complied should have been on the record. Why did you do it at your colleagues? Or why did you advise your colleagues also to do the same?
So I don't understand his prayer. Is he suggesting that the lawyers who are not on this list shouldn't even be here? I don't know the prayer he's making.
No, they shouldn't be on the record.
Yes?
They shouldn't be on the record. I think you have not appreciated the legislation. It is not my law. Read it.
I think I want to reiterate the position of the Honorable Ronde Mayor that my colleague in uniform is on a mission to mislead this Honorable Court. And he's doing well in that direction. If he had taken the time to read Article 28 of the Constitution, which I'm going to read for him, Article 28(1) guarantees the right to a fair hearing and guarantees the right to a lawyer of his choice and defense facilities. Article 44, paragraph C of the same Constitution says that this right is not negotiable in my language, but in its speculation it uses English of non-derogable. Notwithstanding anything in this Constitution, there shall be no derogation from the enjoyment of the following rights and freedoms. Paragraph C is the right to a fair hearing. The right a fair hearing includes the two accused persons choosing their lawyer, which they have done. You can't tell them, even now they can appoint a lawyer. Now as we're proceeding, they can even fire us and replace us. That's fair hearing. That rule you are quoting is null and void. Article 2 of the Constitution is very clear that if any regulation, rule, speech from the prosecution is inconsistent with the Constitution, the words of the Constitution, Chairman and members of this court, is such a things as he is saying are null and void. That is Article 2 of the Constitution. Will this court follow null and void submissions, or will it follow the provisions of this Constitution? Thank you very much.
I don't know where my colleague has gotten the jurisdiction to pronounce the law null and void. We Article 137.
Said regulations, not the law.
It is a law regulating the law. So where do you get the mandate? You, Kiiza.
I went to law school for 5 years to study law, and this constitution was promulgated in 1995, and Article 221, these articles are in my head, says that UPDF shall promote, respect, and protect this constitution and the fundamental human rights of Ugandans. And we are saying the right to a fair hearing is not negotiable. And we are saying the right of Besigye and Rotary to choose their lawyers, even to change them, is not negotiable. So if you have not read those specific provisions, you shouldn't come here to mislead the court.
You should come when you are prepared.
I am prepared. That's why I'm reading the Constitution and you are reading the rhetoric.
Mr. Chairman, if I may, and I know I am perhaps one of the subjects of the objection, if the court will allow me to just address it. I think my learned friends have made very clear what the Constitution says. The right to appoint counsel is a prerogative of the accused. What the state is citing is an administrative process of notification, so that we tick boxes, we dot the I's, we cross the T's. But that is a technicality. And that same Constitution, being aware that there may be instances of this nature, then requires that substantive justice is administered without undue regard to technicality. It's not a question of completely ignoring it, but it's undue. And perhaps there are practical ways of dealing with that administrative problem that the court has been made aware of. The accused are here. They haven't yet spoken and said that the list of people that was read here is a list of masqueraders. I believe they can confirm, if they are required to do so, that the list as read are their lawyers, so that we move on to something else. If there is a simple administrative matter that hasn't been complied with, it can be complied with in due course. If there is need to have a look at our practicing certificates, thankfully we have a practice of walking around with them for this very reason, so that we are then able to satisfy you that we are not here to spend the morning engaging in semantics, but we are here for serious business. I thank you, Mr. Chairman.
I think, sir, I have listened to both sides. One, there are two issues, and it is not yet resolved. the address of the lawyers who filed their PCs with court is General Court Martial, and I believe you have law firms where you practice from. So is this an authentic document? Who filed it before this court? Then two, if you say it is an administrative order, we don't want to be restricted in law. All of us studied the 5 years you took in school, we also took them. So when he's putting on that uniform, you should know that he spent the same years you spent. If you have attached your certificate, why have others not attached? And you cannot say that instructions, if they are in a law firm, yes, you can. Did you comply with the regulations and file within the 24 hours, which is required? So you cannot run away. Others have provided, and then you say there's no need to provide. Why did you comply and others didn't? So still, those who have complied with the regulations can go ahead and address court, and others also must either go on record and file instructions. If you want to challenge it and it becomes a constitutional issue, you can take it on from there. But that is my advice to this court, sir.
Most obliged.
So, Councillor Lukwago, are you ready to continue with that group which has fulfilled the instructions?
Mr. Chairman and honorable members, earlier on we made a prayer that we be permitted an opportunity to have an interface with our clients here. It's one of the issues we're going to address. If we may be granted that opportunity to discuss, all these issues are rising because of the fact that we have been denied access to our client. Even when he came in here, it was difficult even to wave at him.
But Council, how did you arrive at that number? Did you consult them or you didn't consult? It was your choice or it was their choice?
It was his choice first when we met him at Luzira. And that was once. If the first time I went to Luzira, I was denied access to him. I even talked to the Besigye, and I told him I have a list of lawyers here. I want to finalize these processes. You can confirm this with the Commissioner of Prisons. They stopped me at the gate there. They stopped me from accessing the upper prison where he was. So what else did you want me to do under those circumstances? I was in charge. The lead counsel had not yet come into the country. So I generate a list as requested by him. I go to Luzira to talk to him to see how we finalize the process of instructions. I'm blocked at the entrance. I seek for the intervention of the Commissioner General of Prisons, all in vain. Now I come here, they raise technicalities. I am asking this one, now that he's here, can I have a word with him over all these issues?
Is there any harm on that? Councillor Lukwago, you are given 30 minutes as you requested to interact with your clients as we proceed.
Your Honorable Court would like guidance on the provision for interacting with him, because we are not free to interact with him with all these other people. We need a private space where we can interact with Rotary and the Besigye and advise them on confidential issues that are protected by the lawyers-client relationship, confidentiality issues. Thank you very much.
Use the other room, the first room, as you... Huh? Or he can provide the space, this one. But I did not hear his name on the list. We are proceeding, and in case those who are behind, in case you want to move out, please go politely, either to ease yourself or whatever, and then you come back. We don't expect a commotion. I think, Lord the Mayor, now you can address the court.
Thank you, Mr. Chairman and members. Representation is as before. We have been instructed to seek for a short adjournment to process Martha Karua's papers as earlier notified by this honorable court. Because from our discussion with the law council, we are expediting the process. So the assurance that they gave us that tomorrow they are likely to be through. So it's on that premise that we pray for a short adjournment for that particular purpose, so that we can finalize the process, and then probably we can resume tomorrow afternoon, Mr. Chairman. We pray that it's a short adjournment because we really need to have the civil liberties of our clients addressed as early as possible. It's our prayer, Mr. Chairman.
Our council, it may not be possible tomorrow because already the list for tomorrow is there, and the way I'm seeing time, even we may not finish that one of today, which may be carried forward to tomorrow. Register check. On the 8th, 10th. If you have a space.
Chair, we may seek your indulgence, Chair, for this honorable tribunal to accommodate us this week, preferably Wednesday, because today being second, that's yet another week, and it's just a simple matter of processing the PC for the lead counsel and fully constituting our legal team. Yes, we understand you have a busy schedule, but this matter touches rights and possibly the Constitution, so that can be given priority, Mr. Chairman. Wednesday probably would be convenient to us and court. It's our prayer, Mr. Chairman.
We always sit Monday and Tuesday. The third day is always when it is facilitated, but on Thursday we don't sit. On Wednesday we don't sit, sorry. And the consequent days are for of course, for others to organize the files and the rest. I think on 10th, next week is not very far. Can be patient on that. Because this week is already full. So on Tuesday next week.
We need to be guided on Tuesday for what? Mention, because this is a constitutional case. So what is this Tuesday for? It is for what?
Can you answer his observation?
Well, Chair, with all due respect, I thought it is still a prosecution case. It should be known why we are coming back here on Tuesday. For us, we would be happy if our client is discharged. We would appreciate that. But, Mr. Chairman, for the record, we are supposed to come for a ruling. And secondly, Mr. Chairman, for us to have our senior leader here, the senior counsel, properly on record, take charge of the matter. So that's what we have, that's what is bringing us here. But there is a pending ruling which must be delivered by this honorable court on matters of law that we raised, the preliminary matters of law.
So today has been a washout. We are maintaining formation and ruling.
The ruling was not made by the senior counsel thereafter. She was not before court on that day. So we would expect the ruling to be pronounced again if it is ready. Because she had not appeared before court. The ruling does not concern her.
I think, Honorable Chairman and members of this court, with due respect, receiving a ruling is part of legal representation. If, in case there is any confusion about that, we need to clear the air. To represent a client means speaking for them, receiving rulings. Whatever the clients can do, we are here to do it for them. The things that were supposed to happen today are going to happen on Tuesday. They include receiving a ruling, and of course, mention for it has happened, but will happen again on that day. For a lawyer on the other side to say that somehow lawyers who are not ready to receive a ruling must receive it, whether they like it or not, I think he's crossing the legal boundaries.
I think defense, what they are urging is right, unless JA, do you have anything about that?
I have nothing, sir. Let's maintain the same status.
Yes.
Mention and ruling.
We are most obliged.
Yeah. I think that one is over.
Honorable Chairman and members of this honorable court, we propose to start court at 10.
At 10,
Also,
I think it is okay also. Colonel retired Dr. Kiiza and your colleague, your case is adjourned to 10th December 2024 for mention and ruling on issues raised by Road Mayor.
I'll begin by expressing my dismay to the humiliating body search that I was subjected to twice, and all members of the legal profession were subjected to. First at the gate, then as we entered the courtroom, another body search. And I'm asking the officers, between the gate and here, and most people have left their briefcases at the gate. What would make them subject us to a second body search? Secondly, I have not yet had audience, the right of audience in court, because I'm not yet licensed to practice in Uganda. I'm expecting a special license to be issued by the Law Council. As it has been indicated, I applied last week. I was informed that they do not process digital applications, so my physical application was brought on Wednesday, and it was taken by the law firm of Lukwago and Company, and it has not yet been processed, but I have been promised by the chair of the Law Council, Justice Muliagoja, that we may hear from them as early as tomorrow. We have been able to have audience with our client in the court, within the court precincts, and our client was very firm that we ought to apply for adjournment. I should say our clients, not client, so that we can get the answer from the Law Council. You can see for yourself the harassment we have to endure, that they cannot wait even for a minute for this conversation to happen. I want to agree with my colleague, the Lord Mayor, that the abduction of Mr. Besigye and Mr. Lutale from Kenya breaches the Constitution of Kenya, the Constitution of Uganda, and the East African Treaty. I have looked at the charge sheet. The offenses are alleged to have been committed in Kenya, Greece, and Switzerland. Unless if Uganda has annexed Kenya, and we do not know, Ugandan authorities have no jurisdiction whatsoever on anything committed on Kenyan soil. That is, if at all any offense was committed. So we will be raising many objections. I am coordinating Pan-African lawyers from Nigeria, from Kenya, from Ghana, from various jurisdictions, including Tanzania, who will also be applying to practice. As Pan-African lawyers and politicians, we are taking this matter very seriously. We are going to stand in solidarity, and we will file other cases in the East African Community Court, EACJ, against Kenya and Uganda for their illegal conduct. We will be exploring all legal options, and I'm very hopeful that tomorrow I'll be granted a license to practice in Uganda, and that the Law Council will be ready to process other multiple applications. Yeah.
Indeed, there are going to be multiple applications. They should get prepared. Uganda.